Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
The U.S. Supreme Court decision that allowed the Trump administration to proceed with its restructuring plans for federal agencies and the workforce is not the final word. Cases are still making their way through lower courts at the same time as several agencies have issued RIF notifications. Here to help us make sense of the variety of issues is managing partner at Tully Rinke, Michael Fallings. Mr. Fallings, thank you for joining me today.
Thank you for having me.
We're in interesting times, let's say, when it comes to restructuring the federal government, and you've followed these developments closely. How do you interpret the Supreme Court's recent decision to lift the injunction on the Trump administration's reduction in force and reorganization plans?
Well, I view it as a permission for the administration to continue its efforts to reorganize. You know, the Supreme Court decision, I guess one of the earlier ones last week, was an 8-1 decision that permitted, the Trump administration to continue its reorganization efforts. You'd already seen RIFs occur at a few agencies, then that this Supreme Court ruling has allowed other agencies to continue their reductions in force plans, which I know have already continued. I know Health and Human Services was laying off people even. I interpret it as that the administration does have the power to reorganize the government and doesn't need that congressional approval that was being challenged. Now, I think it's important to note, though, that these employees that are being RIF'd or being laid off could still challenge those actions, depending on the type of action and depending on the type of employee they are.
So I want to come back to how individuals might respond to this, but let's keep it institutional for a little while. What kind of precedent do you think this sets for executive authority over federal workforce management?
I think it sets a big precedent as far as allowing, the executive to really take actions that the executive deems necessary. And that has been an issue that, that has been challenged. And we'll see how that plays out in the future when we have a new president, as far as what challenges there may be. But, it does appear, through the recent rulings on, the layoffs, on the termination of, certain employees and certain executives in the government, that the president does have the power to determine who is in the executive branch and can do so without approval from other branches of the government. It can do so through executive order, which, has been occurring. So, this has been an issue, and I think it still will be continuing to be an issue as far as different cases that will come up as far as how much power the executive has. But, this provides a signal that, the president does have that power, to make these determinations.
So taking it one step farther beyond the Supreme Court's decision, the administration has refused to disclose the agency's specific reduction in force plans, citing privilege. What are the legal implications of this approach right now?
Well, the administration does need to provide, a clear path. I think the regulations cite that the reduction in force plans need to be clear and specific because employees can challenge those, like I referenced earlier. They need to be based on specific criteria. So I don't know the merit of any privilege claim, that because this is something that's affecting, the government agencies. The government certainly has the authority to make these decisions based on the recent Supreme Court decisions, but those decisions do need to be provided, and those plans do need to be provided when taking those actions.
So do you think that this current refusal could escalate into a broader constitutional challenge?
Absolutely, I do, because the regulations require, and really any actions against employees do require explanation and evidence and support. That's in the federal government, that's in the private sector. And so, any privilege issue, I think, can and may and will be challenged, and we'll see how the court decides on that.
I'm speaking with Michael Fallings. He's a managing partner at Tully Rinke. You mentioned the Health and Human Services layoffs. We have Department of State. We have Department of Education. But some agencies have walked back their RIF plans, saying that either they met the goal through voluntary separations or hiring freezes or normal attrition. So how would you advise current or federal employees to think about the variety of approaches that they're seeing here?
Well, I mean, I think it's a confusing time, I think, and a stressful time for federal employees, for any agency. I think for those agencies that were already noted in recent decisions, I think the Department of Veterans Affairs, and then we've mentioned a couple other agencies, those employees need to be potentially prepared to be RIF'd. And, in doing so, that means that they need to, I think right now, be gathering, their personnel files, ensuring they have completed their performance records and really just, all the documents they need to ensure that they are before the RIF, because they may want to challenge, the RIF. So I think what those employees need to do at this point. For the employees that were part of agencies that may have walked back, what they're going to do or whatnot, I'm sure they're still stressed and whatnot. If the agencies have stated that they're not planning on conducting a RIF at this point, then, I think those employees, could still continue their employment. But I know they will need to consider, and that I know employees have considered other options, because not only of the language of the RIF, but we've had the return to work orders that have affected people, as well. And I know employees have seen some, even their coworkers, be removed for reasons not based on the RIF. So I know it's a stressful time for those employees, and I know a lot of employers are considering when they can retire and potentially early retirement. So those are things that those employees could consider, even if those agencies have said we're not planning on doing any more RIFs. Right now, we don't know whether the president may next year want to conduct more RIFs, because I know, that's been a stated goal to reduce the government force to a certain percentage, by a certain percentage. So, I think it's still something to be cautious of if you're a federal employee.
So let's talk about the options that federal employees or even unions have in the cases where agencies have gone forward with these RIFs. We talked about continuing legal action, at the institutional level. What recourse might the unions or individuals have?
Well, the main recourse for these individual employees is to challenge the RIFs after they're effective through the Merit Citizens Protection Board. That ability, that's available for employees that, based on their classification of position in a lot of circumstances, but most employees have that availability. They would have to file within 30 days of the RIF notice, of the RIF effective date. And that involves filing an appeal with the Merit Citizens Protection Board that has administrative law judges to review the decision and review whether the government has, classified them as being properly part of the RIF. So that is the main way to challenge it. There may be grievance options as well, especially for the union employees. If, and this may be a more difficult option, but, there is availability to file discrimination or retaliation complaints. I say that may be more difficult given that this is impacting a class of employees. And with those complaints, you usually have to prove that this is kind of an individualized action. But that could still potentially be available for employees as well. But again, the main area is through the Merit Citizens Protection Board. Even beyond that, there may be an opportunity by unions filing class actions or filing in district court. I mean, you've seen that really in trying to stop these actions. But, as far as class actions are concerned, a union may try to move the matter into federal district court and hopefully have a judge find that this is arbitrary and capricious.
We're hearing that claims with the MSPB are already up close to 400%. So they're going to create quite a backlog. How do you think that those cases, as they work their way through the MSPB, might affect future RIF policy?
That's a great question. I think as far as affecting future RIF policy, I don't think the administration's going to really take that into account. I think that the administration's probably going to continue its RIFs because those employees have to challenge, those RIFs through the MSPB. So it's really the employees' issue. Now, the MSPB is still processing cases. They still have administrative law judges that are adjudicating cases. And even though there's not a quorum at the board, those employees could take those cases that if an administrative judge doesn't find in their favor to the federal circuit. But as far as the RIF policy is concerned, I don't imagine it will change, the RIF policy, given the uptick in cases, because that is the ability, for those employees to challenge those actions.
And do you see a role here for Congress in providing oversight to these restructurings?
Potentially, but I think that was part of the challenge with the administration and, whether or not Congress, does have authority to provide oversight or change or affect, these firings. And that may still continue to be challenged, but the administration, and I think the court has said that the executive has the power to do this.
I've been speaking with Michael Fallings, managing partner at Tully Rinke. Mr. Fallings, thank you so much for joining us today.
Thank you for having me.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Listen to the Federal Drive on your schedule and on your device. Subscribe wherever you get your podcasts.